In July 1980, the Supreme Court of the United States issued a landmark decision in Richmond Newspapers Incorporated versus Virginia, holding that the First Amendment to the Constitution guaranteed that the press had the right to attend criminal trials. This ruling was in response to a constitutional challenge to a judge's decision to exclude the public and the press from a Hanover County murder trial in which the defendant was found not guilty. In December 1975, Lillian Keller was found stabbed to death in her apartment at the Holly Court Motel near Ashland, where she was employed as manager. Chief suspects were Holly Court Motel resident Howard Franklin Bittorf and his close acquaintance John Paul Stevenson. They were arrested, charged with murder, and in separate trials in 1976, convicted of killing Ms. Keller. The next year, the Supreme Court of Virginia reversed the convictions and remanded the cases for retrial, finding that a blood-stained shirt purportedly belonging to Stevenson had been improperly admitted into evidence at the trials. Stevenson's defense attorney, Willard Norwood, requested that his fourth trial be closed to the public because he didn't want any information being shuffled back and forth when we have recess as to what, who testified to what. Commonwealth's attorney Bynum did not object to the defense motion, leaving it to the discretion of the trial judge, Richard H.C. Taylor, who ordered that the courtroom be kept clear of all parties except the witnesses when they testify. Attorneys for Richmond Newspapers Incorporated asked the judge to vacate the closure order, arguing that he should have considered less drastic measures. Judge Taylor denied the request. When the closed trial resumed, Judge Taylor granted the defense attorney's motion to strike the Commonwealth's evidence due to its insufficiency, and Stevenson was found not guilty of Ms. Keller's murder. Richmond Newspapers Incorporated persuaded the Supreme Court of the United States to review the judge's decision to exclude the public from the courtroom. In 1980, the court ruled that absent an overriding interest, the trial of the criminal case must be open to the press. In the following video, Judge David Cadell explores, with then Commonwealth's attorney Patrick Bynum, what led to the judge's decision to close the trial to the public.
Good afternoon. I'm Dave Cadell. I'm a General District Court judge here in Hanover County, and I'm here with Pat Bynum, a local attorney. We're here in the historic Hanover Courthouse. It has some pretty significant history in it. Patrick Henry practiced law here. In fact, he tried the famous Parsons Cause case, which in part led to the Revolution. But we're here today to talk about another historic case that came out of this particular courtroom, one that's very fascinating to our local community here. And I'm interviewing Mr. Bynum because Mr. Bynum was a significant part of that case. So, Mr. Bynum, we're here to talk about Commonwealth versus John Paul Stevenson, a case that you handled as the Commonwealth's attorney here in Hanover County. Would you mind telling us a little bit about it?
Sure, Judge. Thank you. This was a case that started in 1976 as a result of a murder in the town of Ashland. And a woman that was the hotel manager was murdered in her office. And the body was discovered by someone. The police were called. And I'll get into the factual situation. But the participants in that particular trial, and we had 4 trials of the same case. And what happened was, and the people that were involved are very interesting. The judge, Edward P. Simpkins, and he was at the end of his career. He had the legislature had a law, and it's still in effect. When a judge turns 70, there's mandatory retirement, and he had retired in 1978.
It's now 73. Gets me a little bit extra.
Oh, it's 73 now? Okay. Yeah, there you go. The defense attorney was an attorney named Willard Norwood, and he was from the Mechanicsville area. He had an office down there. He was a sole practitioner. I think he had a nephew that entered the bar and practiced with him for a little bit. But Willard Norwood and I were friends. He was a very tenacious type of an attorney. And when he grabbed onto something, he wouldn't let it go. And he was an excellent defense attorney. Did a good job. And he had been practicing at that point probably 30 years or so. He was a little bit older than I was, because I was a young whippersnapper at that point, but I was very young and inexperienced. But Willard Norwood knew the law very well. He's an excellent trial attorney, and he represented Mr. Stevenson, and there was a co-defendant by the name of Bidoff who was tried separately. Mm-hmm. And basically what Willard Norwood and I would do, we would try Mr. Stevenson to find out what the outcome of that was, and we may have been able to settle Mr. Bidoff's case. The case itself was very unusual, and as I said before, there was a woman that was a hotel manager in a town of Ashland. It was a small motel, and basically the people that stayed there were people that worked in the area, and they would rent rooms on a week or monthly basis.
One of those residents was the defendant, Howard Franklin Bittorf, whose rooms adjoined those of hotel manager Lillian Keller. After Ms. Keller was found stabbed to death in her apartment, suspicion immediately turned to Bittorf and John Paul Stevenson, who had arrived at the motel within a day of the murder. Virginia State Police investigator William Schultz traced the suspects to Baltimore, where he visited Bittorf's apartment and there met two women. When Schultz asked to be given the clothes that Stevenson changed from when he arrived home on December 2nd or 3rd, he was given a knit pullover shirt. Former Commonwealth's attorney Patrick Bynum explains what happened next.
Investigator Schultz got the items and came back. And he didn't have a search warrant. He didn't go into the house. He just asked for clothes, and this was what was given him. He took the clothes to the state lab. They were analyzed, and some of the blood on these clothes, allegedly worn by Mr. Stevenson, matched with the blood on the victim and at the crime scene. So at that particular point, I estimated wrongly that I had a very good case. So we tried the case, and the jury was convened. Took the jury box, and we tried the case, and I introduced this evidence, the bloody shirt, and Mr. Norwood objected. He said, "That's hearsay." And I said, "No, it's not. It's not hearsay primarily because nothing was said to anyone."
There was no statement made.
There was no statement made to anybody. It was, "Do you have this?" It was given to the investigator, and he came back, and there was nothing there.
And Judge Simpkins agreed with you.
Judge Simpkins agreed with me, and I felt on firm ground because, again, he had never been overruled, and especially in a criminal case. And there was conviction, and Mr. Stevenson was sentenced by the jury, and it went up on appeal. And the Supreme Court reversed and remanded for trial. And the reason they reversed it and remanded it for trial because they determined that the items given to the investigator by Stevenson's family member, it was hearsay. It wasn't hearsay in the normal sense of the definition. They called it non-verbal hearsay. And that decision itself was precedent-setting because no court had ever ruled, at least in Virginia, and I think probably in most jurisdictions, that there was such a thing as nonverbal hearsay.
And the court's reasoning, for those watching or listening, was interesting in the sense that hearsay is typically a statement that's given. And so I think their reasoning was that since the investigator had asked if there was any clothes that were provided, that her going into the interior of the home and obtaining these clothes and handing them over to the investigator, that in essence was her reply to the investigator's inquiry.
That's correct.
And so that was a nonverbal statement in essence response to the question.
And it was, like I said, it was a precedent-setting ruling. And at that point, the case was remanded, and the case was tried in 1976.
1976.
And went into 1977.
So now we have a second trial.
Right, a second trial. We're still in this courtroom. And at that point, Judge Simpkins had retired because of the mandatory retirement age. And then his replacement was Richard H.C. Taylor.
Yeah.
And Judge Taylor, again, was a local jurist. He was his first time on the bench. A little background about Judge Taylor is that he lived and grew up in Hanover Courthouse. I mean, this was his stomping ground, so to speak. But Judge Taylor, like Judge Simpkins, was very, very bright. His manner of running the court, however, was completely opposite of Judge Simpkins, because Judge Taylor ran a very informal court, and so there was a change in style. It didn't change the rules of law or what you're supposed to do in court, but it was a different change. And so in 1977, we had another trial.
You never even made it to a verdict, did you?
No, well, what happened was, in that particular case, we got the jury in a box, qualified them, we started the trial, and we were going through the process, and I'm not sure how far we'd gone in the trial, but the jurors took a break, and one of the jurors had to leave. And I'm not sure, I can't remember whether the juror was sick or had obligations that he or she had to leave. And the trial had lasted longer than he thought it would be.
And it's usually the case that in a jury trial we have some alternates.
That's correct.
No alternates in this case.
No alternates. And so as a result of that, Mr. Norwood asked for a mistrial. The judge granted the mistrial, so there we were back again, 2 trials, and we hadn't concluded everything.
So here we go a third time.
We'll go a third time. And so this time, and this is in 1978.
1978 was the
I
third
believe,
trial.
right. And so we went through the process again. The same people were there, Judge Taylor, Mr. Norwood, and myself. And there was a juror. It was talking about the case, not from the standpoint of what went on in the courtroom, but he told other jurors that he had read about this case in the past, and there had been some issues there.
In the local newspaper.
In the local newspaper.
And this is really important for what's coming up.
That's correct.
So the judge and you and Mr. Norwood find out that this juror had not only read information in the paper related to the case, which probably he shouldn't have done, but in addition to that, worse, was talking to the other jurors about it. So they're receiving information that's not presented at trial, subject to the rules of evidence, et cetera, that we're so careful about to make sure that good evidence goes before a jury.
So as a result of that, Mr. Norwood and I jointly, I think, asked for a mistrial because of that, because the jury was tainted.
So here we go again.
So we
Fourth time.
Fourth time. And this is, I think, in 78, 79, in that neighborhood, I think. And we tried again. But at this point, Willard Norwood, because of the publicity we had about this case,
And what just happened in the third trial.
right, he said, Judge, I would like to close the courtroom and exempt the public from coming in, because we want to get through this trial and we can't have any more adverse publicity, and this thing will never get done. And another reason is it's not fair to my client, because this is his 4th time in the same trial. And Judge Taylor questioned him, asked him about his motion, and then he got to me. And I concurred, and I concurred for several reasons. Number one, there was a U.S. Court of Appeals case that was recently rendered, where the court in pretrial motions and pretrial hearings had excluded the press and the public from the court for reasons of publicity and for reasons of safety, and there were other issues that were the judges in that jurisdiction thought that the court should be closed. And I based part of my agreement on that particular case. Number two is that I was worried about whether or not we would have speedy trial issues. In fairness to Mr. Stevenson, I was prosecuting, but I have a duty to be fair as well as being a prosecutor. And as a result of that, in the press, and this was the fourth time, I agreed.
And to Mr. Norwood's point too, he believed, I think, that it was his client's right that was really being waived. A right to a public trial is provided in the Sixth Amendment, and he was willing to waive that.
That's correct, and I concurred with that too. So the court agreed with Mr. Norwood without my objection, and we closed the court to the public, and we commenced the trial. And things were going smoothly as far as getting things moved along, and the evidence was presented, and we were making motions and arguing different points of law. And about 4 o'clock in the afternoon, which is actually about this time, we hear this bam, bam, bam on the front door of the court.
On those doors right there.
Those doors right there. And I'm thinking to myself, what's going on? And the bailiffs in the courtroom, all of a sudden, they have hands on weapons like, what's going on? And Judge Taylor says, what in the world what's somebody doing out there? Bailiff, go out there and check on what's going on. So we stop proceedings here. The bailiff goes out, and there's a gentleman out there who is an attorney, well-known attorney, and he represented the Richmond Times-Dispatch.
Which at that time was the Richmond Newspaper. That's
correct. There was a Times-Dispatch morning news leader in the afternoon, and he represented the paper. And he said, I would like to talk to the judge. I'd like to be let in. I have a motion before the court. And so the bailiff comes back and tells the judge what this attorney had said, and then the judge said, well, what's the name of the attorney? Went back, got the name, and the judge knew the attorney, and he was a well-respected attorney. He was well-respected in the legal profession, and he was an outstanding person, but it was extremely unusual to say the least. And so the judge lets him in, and he comes up, and I'm sitting here where you're sitting, which is where the prosecutor sat. Mr. Norwood was sitting on the other end of the counsel table, and the attorney sat right here stood right here in front of the judge. Said, Judge, I'm here to object to the closing of the court, and I demand that you open this court so the public can come in and hear the trial.
Including the press.
Including the press, because the press was part of the public that was excluded. And representing the media, the print media at that time, the press was excluded. And Judge Taylor had a conversation with this gentleman, and he said, what law do you have? And they discussed that, and the attorney basically went into his briefcase and pulled out a memorandum in motion. So, Judge, here's the motion. Here's the memorandum to back it up, and you don't have a right to close the court. And I would like for you to rule on this immediately. And so the judge asked Mr. Norwood what his position on it was, and Mr. Norwood says, I disagree. We have a right to close the court, and I would ask the court not to hear this motion or if you hear it, deny it. And I took a neutral position. I was representing the state, and I said, Judge, I'll defer to the court. We've closed it, we've gone this far, and I don't see why we should change it, but you make the decision. And so there was about a half hour of argument between the court and the attorney for the paper, and they were talking about different laws and different statutes and different case law. And the judge said, I'm familiar with this particular statutes that you're referring to. I'm familiar with these cases. I disagree with you, and I deny your motion.
The case goes all the way up to the Supreme Court of the United States.
Right. Well,
That issue.
that issue went. Well, in the Stevenson case, we finally got to the point that there was a not guilty verdict.
Right.
Primarily because of the non-verbal hearsay ruling by the Virginia Supreme Court in the first case, and the Commonwealth had no real
That key piece of evidence, the
Key
bloody
piece of
T-shirt,
evidence.
wasn't admissible. So it's very circumstantial at that point.
yes. And so, as far as I was concerned, the case was over. But it didn't end there. In 1980, the Richmond Newspaper filed suit in the federal courts, and I believe that there was a Harvard law professor, Lawrence Tribe,
That's correct. He represented the Richmond
represented the
Newspapers.
newspaper, and I was out of it, obviously, because it went to the federal level. But the case in the Supreme Court, U.S. Supreme Court, that was brought by the Richmond Newspaper and argued by Mr. Tribe was equally, if not more significant than what happened here locally. Mm-hmm. The precedent that was set here locally was very significant from a criminal standpoint, and it's still the law today. And but the issue with the U.S. Supreme Court was even more significant from a constitutional standpoint. And basically what it boiled down to, it was a argument by the newspapers saying that you cannot close court to the public for any reason, and that's a violation of the First Amendment. And I'm being very
broad about the ruling.
yes, I mean, and it was a multi-page ruling. And the Supreme Court ruled in favor of the Richmond newspaper. And so at this point, unless there is, and I'm not sure if the court made any distinctions or had any exceptions about whether you could close a trial if there's a danger to people inside, that type of thing, but I don't know whether that's ever occurred. But basically, the First Amendment won out in that particular case.
Yeah, I think the Supreme Court of the United States looked at it from the perspective of the First Amendment right to free press. Inherent in that is for the press to really report on what the government is doing and the matters of the government, and even kind of appreciated that the Sixth Amendment right to an open trial, albeit certainly the criminal defendant's right, no doubt, but also kind of extends more broadly that right is also inherent to the community to be involved in that sort of thing and the criminal process to make sure that everything's done correct. And I was pointed to a newsletter by the University of Virginia Institute of Government. It's from May 1985. But I thought that there was a paragraph in this article that really is a great example of why the Supreme Court came to the conclusion it came to, or at least pragmatically in this case. In the article, the author writes, moreover, talking about the fourth trial, moreover, Stevenson was found not guilty, but not as the consequence of the jury's verdict. Instead, Judge Taylor affirmed a motion by defense counsel for a dismissal because the case against Stevenson, without the evidence of the bloodstained shirt, was only circumstantial. Yet the details of both the evidence against Stevenson and the basis for his acquittal remain obscure because the trial was closed, no trial transcript was made, and a tape recording of the trial and Judge Taylor's ruling was largely inaudible. So the point, again, I don't know that that's exactly what the Supreme Court was looking at, but that's a great example of what they were trying to get to. That, look, if we're going to have these criminal trials, obviously we are, that, not only for the defendant, but also for the community and for the press to be able to report, to make sure that, like the other two branches of government, that here in the judiciary, that everybody has an opportunity to see and read for itself about the process and how things are occurring, to be involved and to understand it, and to make sure that their government's held accountable.
And I concur with that. And especially being a defense attorney now, even more so than a prosecutor. But I personally learned a lot from that process. It was educational, and it was interesting to be in the situation I was in.
So as important as the case was to those people involved, certainly the victim, the victim's family, I suppose, and the defendant, what is very interesting about the case is that here in Hanover County, Virginia, not only did Patrick Henry practice law in this courthouse, in this particular courtroom, and all the incredible history related to that, but also it's unusual for a case to go all the way up to the Supreme Court of the United States, much less go to the Supreme Court of the United States and be what we call a seminal case.
Yeah.
The first important case where the Supreme Court articulates a newly established rule, so to speak. And this is an example of that, where out of this Hanover County courthouse, the Supreme Court of the United States, for the very first time, made just an incredibly important historical making precedent and ruling on that case. And certainly your involvement in it is fascinating, and we appreciate your time for telling us the story.
Well, thank you, Judge. I appreciate the conversation.